I couldn't understand. I said to myself, he's coming soon. He's okay. He's fine. We waited and we waited. Finally, detectives came. They didn't look at us. They all looked sad. I didn't hear anything until I heard the words, Alex didn't make it. What do you mean Alex didn't make it? I couldn't believe it. It's impossible. I was stunned in silence. How this happened? Why this happened? I kept thinking over and over. We just celebrated his 19th birthday 2 weeks ago. I couldn't see my son for 4 long days. When I did, he was lifeless in a casket. I knew that my son had been taken from me forever. I remember touching his hands, his face, how cold they were. My Alex is gone. When he gathered at the beginning of his body, everyone talked of him being in heaven. I felt no consolation in those words. I had a vision that he was crying. He didn't want to go. That's why he was showing me his tears. He really wanted to live his life. Alex was thoughtful and compassionate young man. It was natural for him to do random acts of kindness for others. All his friends said they had never met such a genuine person. He truly was a light of hope to others, and now that light has been taken from us. I saw the crime scene. As a mother, I sensed everything Alex had been through that morning. I felt his tremendous fear and pain. I was so devastated. It was horrific. Since that moment, it's always in my head and never leaves. So many days I couldn't sleep. So many days I cried. I smile, but my heart is always heavy. My sadness never goes away. How do I get through this? I will never get through this. Never. He was excited working in his new job and was saving money for his new car. He told me he liked his professors and was very serious about finishing his education. and move forward with his life. Everything was going right direction. Alex loved his brother very much, and they were looking forward to playing golf together. Now everything changed. Everything stopped. The news coverage always shows a picture of Alex smiling, but the truth, he is not here. The real picture is Alex in a casket alone. A senseless and avoidable crime. God did not take Alex. It was an act of pure evil. Alex was at the right place and the right time. They came to the wrong place at the wrong time. Norton Bernard and Bessman Okafor both are very violent, very dangerous to our society. Please do not underestimate them this time. It bothers me so much every day in court that you, Norton Bernard, and Bessman Okafor were smiling and laughing through the trial. The Bible says in Proverbs, when justice is done, it brings joy to the righteous, but terror to evildoers. Therefore, Judge Kest, I hope you honor and do justice for my son Alex, Brandon, Will, Brianna, and our community, so that Norton and Bessman Okafor will never have the opportunity to commit these violent crimes against any other innocent people. And Bessman Okafor, this will not be the last time you see me standing right here. Thank you.
Mr. Malik, anything additional?
No.
Mr. Davis?
No, Your Honor.
Mr. Clark? Thank you, ma'am. Mr. Malik, any additional testimony?
Yes, Your Honor. The state would call Will Harrington.
Okay, Mr. Harrington? Sir, I need you to stand up. Raise your right hand, please.
Do you solemnly swear the testimony you shall give shall be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Please be seated. Tell us your full name, sir.
William Harrington.
Okay, please proceed.
Thank you. Good afternoon, Will.
Good afternoon, Mr. Malik.
You actually were one of the victims in this offense on May 9, 2012.
Yes, sir.
And what would you like the court to know?
Well, I'd just like the court to know that this event has changed our lives in more ways than I can describe. You know, I don't feel safe being around anywhere without looking over my shoulder. You know, things just aren't the same, especially with somebody taken out of my life now. And the scumbags that sit over there today, I just hope that maybe you could just feel some of the pain that we feel. Because you guys disgust me. You're disgusting. And I know Alex would love to be here, just sending them to jail for the rest of her life. So you can never walk to the store again and get a soda. You can never do anything again. See your girlfriend, nothing. And I really wish he was here to see us today. Because I know he would love it.
Mr. Malik, anything else?
No.
Mr. Davis?
No, Your Honor.
Mr. Clark? Okay. Thank you, sir. Mr. Malik, additional testimony?
Your Honor, just for the record, Brandon and Brianna are here in the courtroom, but I don't believe they wish to address the court at this time.
Is there any other testimony or evidence that you would like to present with regard to the sentencing?
No, Your Honor.
Mr. Davis, on behalf of Mr. Okafor, is there any testimony that you would like to present?
No, Your Honor.
Have you spoken with Mr. Okafor as to whether he wishes to make a statement in this matter?
Yes, I have, Your Honor.
And your understanding is?
Mr. Okafor will not be making any statements.
Mr. Okafor, you have a right to make a statement to the court. Your attorney indicates that you do not wish to. Is that correct, sir, or do you wish to make a statement? Okay, thank you. Mr. Clark, do you have any additional testimony or any additional evidence that you would like to present on behalf of Mr. Bernard? Okay, Mr. Bernard? Anything else, sir, that you would like to tell us? Mr. Clark, anything additional?
No evidence, Judge.
Okay. All right, let me find out the state's position on this matter, and then we will come back. Mr. Mallett, with regard to, let's, if we can, deal with Mr. Okafor first. What is your recommendation and request with regard to sentencing as to count 1, count 2, count 3, count 4, and count 5, which are the only remaining counts?
Your Honor, the state's request is the court sentence Mr. Okafor as a prisoner releasing reoffender to the maximum amount of time. Specifically in regards to count 1, it's a life offense, so he should be sentenced to life as a prisoner releasing reoffender. As to the other 4 counts, the state is asking for they're punishable by life offenses, and again, the state is asking that he be sentenced to concurrent sentence of life on all 4 of those counts as well. Your Honor, the state's position is even if he was not a prisoner releasing reoffender, the court can see his record. The court's also familiar with the facts of the case, the evidence in the case. 4 innocent kids home during the day, robbed at gunpoint, tied up in their own home by 2 individuals that they had never seen before. This is certainly the type of offense that he should be sentenced to life, even aside from the prisoner releasing reoffender status, Your Honor.
And your request is, you mentioned counts 2 through 5.
That he be sentenced to life concurrent with count 1.
Okay. Concurrent, all counts?
Yes, Your Honor.
Okay. Mr. Davis, on behalf of Mr. Okafor, your response with regards to counts 1 through 5.
May it please the court, as I probably prematurely said to the court earlier during this proceeding, that I am very much aware that this honorable court is bound by the Prison Release Reoffender Act and its legislative intent. I equally understand that this honorable court has seen all the evidence submitted today, documents submitted today, and so forth by the state. I also understand that the court may be bound to the point where the court may not have any options before it for leniency. With that being said, I ask this honorable court on behalf of Mr. Okafor for leniency in light of the aforementioned and in light of the matter before this honorable court this afternoon.
Thank you. With regard to Mr. Nolan, Mr. Bessman Okafor, the jury has found you guilty as to multiple counts. The state has asked the court to vacate count 11, 12, 13, and 14. did not go to trial on counts 6, 7, 8, 9, and then 10 was dismissed at the conclusion of the trial. You therefore are to be sentenced to counts 1 through 5. The court has found the state has met its burden with regard to enhanced sentencing under PRR. The court finds you are to be sentenced under PRR. As to count 1, which is the burglary of a dwelling with an assault or a battery with a firearm, that is a life felony. The court is going to adjudicate and sentence you to life. With regard to count 2, which is robbery with a firearm, which is a F1, but is a PBL, that is the case involving Brianna Campos. The court is going to adjudicate and sentence you to life. With regard to count 3, which is a robbery with a firearm, again an F1 PBL, it's the case involving Brandon Campos. The court is going to adjudicate and sentence you to life. With regard to count 4, robbery with a firearm, which is an F1 PBL, the court is going to adjudicate and sentence you to life. And with regard to count 5, robbery with a firearm, count 4 was victim was Alex Zaldivar. With regard to count 5, robbery with a firearm, an F1 PBL, the victim was William Harrington. The court is going to adjudicate and sentence you to life. Each of those counts is to run concurrent with each other. Counts 1 through 5 are sentenced under the PRR in these particular matters. The court finding that PRR is applicable. You are entitled to credit for time served. Madam Clerk, you have a credit for time served as to Mr. Okafor?
Yes, 1 year and 71 days.
You'll be given credit for 1 year and 71 days time served. The court is also going to impose court costs. Madam Clerk, can you announce the court costs in this matter?
Yes, $418 court costs, $100 state prosecution fee.
Mr. Davis, the court can send these matters to collection court, or I can reduce them to a judgment. Do you have a preference, sir?
I believe it's appropriate for this honorable court to reduce it to a judgment.
All right, we'll go ahead and reduce those court costs to a judgment in this matter. Mr. Malik, is there restitution with regard to any of the victims with regard to counts 1 through count 5?
Your Honor, I'm asking the court to order in reserve. I believe most of the items were recovered. I think there might have been a watch or something that maybe was not. So I just ask the court to order in reserve at this time.
Mr. Davis, any objection to that?
No objection, Your Honor.
The court will order restitution reserve as to the amount, require the state to prove up restitution within 60 days or be discharged without further order of court. Mr. Davis, would your client like to be present if there is a restitution hearing in this matter, or would he like you to go forward without being present?
May I speak to my client briefly about that, Your Honor?
You may.
Your Honor, my client does not wish to be present.
Okay. All right. Thank you, sir. Mr. Malik, is there anything further with regard to Mr. Okafor?
No, Your Honor.
Mr. Davis?
No, Your Honor.
Mr. Okafor, you have 30 days to appeal the decision of this court, the judgment and the sentence. Your appeal must be in writing. An attorney can be appointed to represent you in this matter. In this case, sir, you are discharged at this point. You will remain in custody. Mr. Bernard, I have listened to what you have told the court in this matter. You were found by a jury to be guilty on the charges that went to the jury. Those were counts as 1, 2, 3, 4, 5, 11, 12, and 11, 12, 13, and 14. The state has vacated or asked the court to vacate 11, 12, 13, and 14. The court has to sentence you on counts 1 through 6. The court did find and has previously announced that you qualify as a prison release reoffender in this matter under PRR. The court is going to sentence you as such. Yes, sir.
I don't believe that either the state or myself we haven't given our input yet. We haven't given that.
Oh, I'm sorry. That's my mistake. You're right. You asked me to do these separately, and I purposely waited for that reason. So let me have you. Mr. Mallix.
Judge, my position in regards to Mr. Bernard is the same. We're asking the court, based on the finding that he is a prisoner release reoffender, that he be sentenced on count 1, the burglary dwelling with an assault or battery with a firearm. Since it is a life offense, that he be sentenced to life as a prisoner release reoffender, day for day. As to the other 4 counts of robbery with firearm, as to each victim, again, we're asking that he be sentenced, since they're punishable by life offenses, that he be sentenced to life on those counts as a prisoner release reoffender, concurrent to count 1. And again, the state's argument is the same. Even if he were not a prisoner release reoffender, the offense itself is certainly something that would justify the sentence of life imprisonment. Again, the facts: 4 innocent kids are home alone during the day. They're held up at gunpoint by Mr. Bernard and Mr. Okafor, 2 individuals they don't know. The house is ransacked and they're tied up and left at the house. And they still feel the impact of that offense today, as the court has seen through the various statements of the victims and the victim's family. Again, the state's position is even if he was not a prisoner release reoffender, he certainly should be sentenced to life imprisonment based on this offense.
Mr. Clark, let me let you go ahead and proceed. I know Mr. Bernard has told me his thoughts a moment ago, and I know you understand that the court's sentencing parameters are very limited with the finding in this nature, but let me have your position in this matter, sir.
Thank you, Judge. To a large extent, I agree with Mr. Bernard. I think the state is being disingenuous with regards to what kind of sentence Mr. Bernard would expect to have not been subjected to being tried for Mr. Okafor, which was let out of here by the jackboots on. This is the kind of case where the state very well might have made an offer had Mr. Okafor not gone and allegedly killed Mr. Zalabal. They didn't make an offer because of this secondary issue, during which time Mr. Bernard was incarcerated and had nothing to do with it. Everyone knows that he had nothing to do with that. So I don't believe that it's true that the state would have been seeking a life sentence in any event. I believe this is the kind of case where they would normally have made an offer, and they didn't solely because of the actions of Mr. Okafor that followed the original offense. I believe that it made it very difficult for Mr. Bernard to get a fair trial, having a circus in front of the courtroom, inside the courtroom, and around the courtroom throughout the trial. I can't say that the jurors were subjected to media. I'm sure they tried their best not to, and perhaps they didn't see anything. But it certainly would be difficult for that to happen. Also, Mr. Zalabar's family, rightfully so, was outside and having vigils and making their presence known. And that makes sense, and there's nothing wrong with them doing that. The issue, though, is that those things that they were really there for have to do only with Mr. Okafor. Obviously, they would be angry and upset with what Mr. Bernard had been convicted of doing. But even Mr. Zalabar's mother's testimony about how he was doing and how he was moving on with his life and everything seemed to be going well for him when Mr. Okafor allegedly did what he did. And I think that the folks had moved on so much, so it doesn't diminish the crime and everything he did, but it does paint it, I guess, in somewhat a different light than it is currently due to what happened afterwards, which has absolutely nothing to do with Mr. Bernard. So the court has no discretion, as you're well aware, regarding finding that he's prison release and you have to sentence him to life. But I think this is a good example of why cases should be settled in certain circumstances, particularly when one co-defendant has done something that is allegedly done something that is so bad afterwards that there's nothing, it can be nothing but taint in the other person. So I think that may be well what happened in this case.
Okay, thank you. I have listened to the argument of counsel in this matter. The court has made a determination that the state has met its burden with regard to a PRR status, which limits the discretion of the court. As to count 1, the court, which is the burglary of a dwelling with an assault or battery with a firearm. The court does adjudicate and sentence him to a life in prison. As to count 2, which is an F1 PBL, robbery with a firearm involving Brianna Campos, the court does adjudicate, sentence him to life. With regard to count 3, robbery with a firearm, this is involving Brandon Campos, the court does adjudicate and sentencing him to life in prison. With regard to 4, robbery with a firearm involving Alex Zandivar, the court does adjudicate and sentence him to life. With regard to number 5, robbery with a firearm involving William Harrington, the court does adjudicate and sentence him to life. Each of those 5 counts are to run concurrent with each other count. Each are sentenced as a PRR count in this matter. The court, as I indicated, has adjudicated in this matter. I've indicated they are to run concurrent. He is entitled to credit for time served. Madam Clerk, what are the credit for time served from Mr. Bernard?
1 year and 154 days time served.
He will be given credit for 1 year and 154 days time served. Court costs are to be imposed in this matter. Madam Clerk?
$418 court costs, $100 prosecution fee, $100 attorney fee, and $50 fee.
Mr. Clark, would you like those matters reduced to a judgment as opposed to going to collection court?
That's fine, Your Honor.
All right, they will be reduced to judgment in this matter. Mr. Malik, is there a restitution issue with
No,
regard to
Your Honor.
Mr. Bernard?
I'm asking for the same, Your Honor, as the court to order reserve. I
Court-
believe there may be 1 or 2 items that weren't recovered.
The court will order restitution reserve as to the amount. Mr. Clark, would your client like to be present for any restitution hearings?
No, Your Honor, you would not like to transfer it back, and also I'd ask that we be appointed for purposes of appeal.
All right, he will not have to be transported back. The court will order restitution reserve as to the amount required to be proved up within 60 days. Mr. Bernard, I'm going to advise you that you have 30 days to appeal the decision of this court, the judgment and the sentence. The appeal must be in writing. Your attorney has requested on your behalf that I appoint public defender for purposes of appeal. The court is going to go ahead and do that at this point. They'll provide me with an order. I'll be happy to sign that in this matter. Mr. Malik, is there anything additional?
No, Your Honor.
Mr. Clark, anything additional? No, sir. All right, thank you.
Your Honor,
Yes, sir,
may it
Mr.
please the
Davis.
court, I would also ask this honorable court to appoint the public defender's office for the purposes of appeal for
Mr. Okafor,
Thank
the court will so appoint. All right. Mr. Malik, anything additional for this court?
No, Your Honor.
Mr. Davis, anything additional?
No, sir, Your Honor.
Mr. Clark, anything additional? All right, this court will be in recess.